Good day, everyone. We are the Group 8. So, our topic is appearance and subpoena. I'm Angel Jean Amarbanta.
And I'm Loreto Milana.
And I'm Archie Banto.
And I'm Jomari Pinamino.
And we are the reporter.
First of all, what is subpoena? So, subpoena is a legal document that compels a person to either testify as a witness or produce documents or other evidence. It is a formal court order and cannot be ignored. And also, it ensures evidence and testimony are available for legal proceedings. So, a subpoena is a writ ordering a person to attend a court. A writ or usa ka legal na kasulatan nga ikaw nga tawo pa-attendon sa korte. So, there are types of subpoena. First one is subpoena ad testificandum, witness subpoena. Orders a person to appear in court at a deposition or at a hearing to give a sworn testimony. So, the content of the writ is they want that person to appear in court to give a sworn statement or sworn testimony. So the second one is subpoena ducesticum, subpoena for production. Orders a person to produce specific documents, records, or other tangible evidence at a specified time and place. So, subpoena ducesticum is a writ ordering a person to attend a court and bring relevant documents. A common example of a subpoena ducesticum is issued to a healthcare provider for a patient's medical records in an injury case. Even with privacy laws like HIPAA, a subpoena is a legal mechanism that allows the court to obtain specific records necessary for the case, overriding the unusual privacy protection under certain circumstances. So, what will you do if you receive a subpoena? So, first things first is how it works. A subpoena is typically served in a person to ensure the recipient is officially notified. So what to do? Do not ignore it. Number one, do not ignore it. It is a legal court order. So if you receive a subpoena, you must not ignore it. And so the second one is review it carefully. Note the date, time, location, and whether you are required to testify or produce the documents. So, when you receive a subpoena, you must take note that the date, time, and location to avoid missing the hearing. And you must read it carefully. Maybe the writ is you must required to testify or you must produce documents for the hearing. So you must check on it if you need to produce documents or you just required to testify on the hearing. So the third one is contact legal counsel for advice on how to respond, especially if you are not a party to the case. So, when you receive a subpoena, you must contact a legal counsel. Because this one, the legal counsel will advise you on how you respond on the hearing. Especially if you are not party to the case.
Requirements to appear. So the duty of a witness. A person has a duty to society to appear and testify in legal cases if commanded. So as a witness, Your duty is to testify and appear in legal cases, and as a witness, you must know the truth and you know the issues properly. For civil cases, a witness is typically compensated for reasonable expenses for travel. So, these cases aims to resolve issues like contracts, property, or family matters. Civil cases seeking compensation or specific performance rather than criminal penalties. In criminal cases, compensation is less common as testifying is considered a civic duty, while testifying is considered civic duty, while witnesses can reimburse for reasonable expenses and lost income. They generally cannot be paid a fee for their testimony in criminal proceedings. So, di sila mabayaran kung kuan mo testify sila nga kuan kanang kagalingon nila ba kanang ginusto din lang amo testify sila. Avoiding in appearance. An appearance may be avoided if a guilty plea is entered or if the witness is excused by the court. So, yes, in some cases, a court appearance may be avoided if you enter a guilty plea. This is because a guilty plea resolves the case without need for a trial, which saves the court time and resources. So, what happens if you don't comply? So, contempt of court. Failure to appear as a commanded can result in contempt of court charges. So, failure ka na mo kuan sa result sa contempt na chance na ikaw ang macharjan. So, financial penalties. You may be ordered to pay fines or to be subject to other penalties. So, kanay financial penalties kay kuan magdepende na ang imong penalty sa unsay imong na labag bitaw like kuan depending on the specific law, jurisdiction, severity of the violation, and the entity involved. So, default judgment. In some civil cases, ignoring a subpoena could lead to a default judgment against party to the lawsuit. Good cause. You may be able to avoid penalties if you can show a good cause for your failure to appear, but this is a high burden of proof. So, kanang pwede ra ka maka-excuse aning sa good cause if nakay valid reason. Responding to subpoena. Identify. Pinpoint the documents or information requested. So, pinpoint is a common term referring to different tools and concepts. Provide specific information ang requested. So, determine whether to comply with or resist the subpoena obtained with legal counsel. So, comply. Produce the requested documents or provide testimony. So, the legal instrument that compels an individual to appear and provide testimony is called a subpoena. So, object or squash. If there are valid legal reasons to resist, you can object or file a motion to quash the subpoena. And last is the objections. Can be based on things like undue burden or privilege. So, an objection of undue burden means the request for information is excessively burdensome, costly, or time-consuming for the party receiving it. Courts will consider the relevance of the information requested versus the burden producing it. If the burden heavily outweighs the potential value, the court might modify or deny the discovery request.
So we proceed to appearance. Appearance in legal context. An appearance refers to a party or their attorney formally showing up in the court. For a technical writer, these terms has two applications: a formal filing in a court and a physical appearance in a legal proceedings to provide testimony. So, appearance is now how you appear in the court to testify yourself or to be a witness, and formal showing up in the court. Formal entry of an appearance. A technical writer company may need legal counsel to file a formal entry of appearance with the court. So, formal entry of appearance notifies the court that an attorney represents the company in the case. So, second one is the appearance as a witness. A technical writer might be compelled to make a personal appearance in a deposition or court hearing to testify, particularly if they involve in the creating of documents that are central to the lawsuit. So, appearance as a witness is on how you testify and testify your knowledge about the case and how you defend your party. So, preparing for an appearance testimony. Understand your role. Know whether you are a factual witness or an expert witness. So, a factual witness is an events they personally experience, such as an eyewitness to an accident. So, an expert witness provides opinions and analysis based on the specialized knowledge or training or experiences. So, na example of expert witness was the doctor or the one is the review information. Go over any relevant documents or records to refresh your memory. So you need to review your information to make your statement relevant in the case that you testify. So consult counsel. If you have a legal counsel, discuss the anticipated questions and topics. So the next one is tell the truth. Always provide a truthful testimony and listen carefully. Make sure you understand the question before you answer. So you must be careful in your what you answer because they use your answer.
Preparing for an appearance. Documents. First is gather all requested materials. Second one is keep originals secure. The third one is make copies. And the last one is arrange for production. So first is gather all requested materials. Ensure you have located and collected all the specific documents listed on the subpoena. The second one is keep originals secure. So maintain a safe location for all originals document. Third one is make copies. In many cases, producing copies will suffice, but confirm with the requestor or legal counsel. And the last one is arrange the production. If you are required to produce originals documents, make arrangement to have a representative accompany them. Technical writer role regarding appearance. First is testifying under oath. Second is preparing for testimony. The last one is drafting legal affidavit. First is testifying under oath. When appearing in a legal proceeding, a technical writer must provide truthful, factual testimony about the documents they created and processes used to create them. Second is preparing for testimony. Before a deposition or court appearance, a technical writer should work with legal counsel to review relevant documents and understand the case. The last one is the drafting legal affidavit. In some cases, a technical writer may assist in drafting an affidavit, a sworn written statement of fact that can be submitted in a court in place of a live testimony.